Welcome to the next startup episode, Start Your Business. The previous episode was devoted to the basis methods of obtaining financing. Among others, I talked about gaining the interest of potential investor in their planned undertaking. In this episode, I will tell you about the activities that usually precede the conclusion of the investment agreement, especially when we are dealing with a professional entity. This is a very interesting issue. First of all, due to the existing standards of conduct used by venture capital funds and many funds operating on the market investing in startups, as well as because due to the good operation for the conclusion of investment agreement, the risk of failure can be avoided at the very beginning. It is worth to mention that the practice of formalizing actions preceding the conclusion of the investment agreement has been largely shaped in the United States of North America. That is why in the Polish regulatory environment, only few provisions apply to it. From the legal perspective, this topic is related to the issue of freedom of contracts, binding nature of the concluded agreements, concluding negotiations in accordance with reliability, as well as protection of business secrets. The Civil Code regulates different modes of contract conclusion, while in the investment process, conclusion of the contract after negotiation is of fundamental importance. All the activities that will be discussed in this episode relate to this process. Therefore, it is worth starting to look at the basis legal norm that regulates it. Article 72 of the Civil Code. It provides that if the parties are negotiating to conclude a designated contract, the contract shall be concluded when the parties reach agreement of all of its provisions that were subject to the negotiations. The three prerequisites regulated in these provisions are the key. The first, conducting negotiations for the conclusion of the contract. The second, reaching the agreement between the negotiating parties. And the third, the agreement must cover all provisions subject to negotiation. Usually, when we talk with business partners, we wonder, or at least we should think about, when we can withdraw from the talks and what consequences of our actions may be. This is a very important issue because you must remember that when negotiating, we must comply with principles of certain business integrity. Keeping them in violation of reliability, in particular without the intention of concluding the contract, may expose us to liability for damages. Other issue that should be taken into consideration before the investment agreement is concluded is to ensure our knowledge against use by entities involved in negotiations. This issue may bring many difficulties, because on the one hand, you cannot talk without revealing the details of a business transaction, and on the other hand, by revealing them, we can be exposed to a loss of market advantage, resulting from our knowledge. This is the main reason why you should enter into confidentiality agreement, in English known as a non-disclosure agreement or NDA for short. Suppose that the initial information sent to the investor, referred to in English as a teaser, caught this attention and we want to start the negotiation process. In particular, to present the business plan we are developing, which will include a detailed financial model of the project. We have already started working on our presentation known as a pitch deck, and we look forward to further talks. Each of your actions is a kind of investment. We invest not only financial resources, but also our own time and even emotions, linking hopes to developing our own enterprise. Bearing in mind the main idea of building our startup, experiment, reduce costs, and manage risk, it is worth investing larger resources from the very beginning only in such projects that bode well. A simple method of verifying whether it is worth continuing to build a relationship with an investor is building a formal correspondence, which legal significance is less important. However, it will be a good testimony to take your idea seriously and willingness to engage in the project. This form of communication adopted in investment practice is a letter of interest. It should be noted at once that this name can be very misleading. It is not a letter of intent, which is an expression of the will to negotiate signed by both negotiating parties, nor it is a letter to a potential employer, usually called this way in English. The letter of interest, which most often contains in its content a number of disclaimers, is only an expression of the very vague will of the investor that under certain conditions he may be interested in investing funds in our venture. Rather, it can be assumed in advance that the letter of interest cannot have any legal effects, since it is difficult to imagine circumstances that would confirm its binding nature. It can also be expected that the investor explicitly states that the letter has no legal effects. Despite this, such a letter may prove to be a valuable document, and it is worth ensuring that the investor agrees to disclose its content to third parties, which can be determined using certain characteristics of the entities. As an example, you can provide part suppliers or financial institutions with which you will apply for a loan or a credit. Sometimes, a letter makes our undertaking reliable without generating much risk and certainly not causing costs. After obtaining initial investor interest, it is time to start specific conversations and show the detail of the project included in our pitch deck. If at this stage the investor is also interested in our idea that he wants to start communication on his part by joining the round of questions, then probably the best solution will be to conclude a letter of intent, which I will talk about later. However, if the investor wants to learn more about our idea first, it is worth ensuring at the least the conclusion of the confidentiality agreement ongoing conversation. The lack of such a contract may mean the lack of actions necessary to keep secret of our company, and thus the loss of protection provided by Article 11 of the Act on Combating Unfair Competition. It is worth mentioning that while the letter of intent and other documents preceding the conclusion of the investment agreement are non-binding, the confidentiality agreement is an act having legal effects and constitutes an unnamed civil contract. A typical confidentiality agreement contains several characteristic elements. First of all, it is the definition of confidential information. In other words, the definition of what information will apply to the parties' obligations. You will need to think carefully about what information is or may be crucial for our venture. Of course, you can assume that the use of the widest list possible is the best solution. However, it should be remembered that the NDA is two-sided bond, and defining the scope of confidential information too widely may prove to be a problem in the future. The Act on Combating Acts of Unfair Competition directly mentions only technical, technological, and organizational information. Most often, however, the confidential information list includes information related to products, marketing or product promotion, or website services, business policies or practices, marketing plans, product or service plans, computer applications, infrastructure, architecture and configuration, program resources, strategies, business information, financial information, forecasts, information about human capital, customer lists, and customer information. Most often, confidentiality obligations are secured by stipulating a contractual penalty in the contract. Although such a reservation is not necessary, but due to the problem of proving the amount of damage suffered, the obligations contained therein may be more possibly enforceable. Properly constructed confidentiality agreement should also contain several important exclusions. Specify what information will not be considered confidential. Most often, they include information that is or will be made public or was in the lawful possession of the receiving party prior to this disclosure and was not obtained by the other party directly or indirectly from the disclosing party. It is also worth noting that information that has been disclosed at the request of public authorities, courts, police, prosecutor's office, tax administration authorities, is not subject to the obligation of confidentiality. Other important elements of the confidentiality agreement are the obligations that the parties should apply in order to prevent disclosure of the information classified as confidential. Here, a very practical problem may appear: the level of security applied. Usually, startup is not able to finance a high-level information security, and certainly not much the venture capital fund in this respect. It may not actually be possible to apply the same obligations to both parties. At the same time, the disclosure party is primarily a startup. Therefore, the NDA should specify higher obligation on this side for the investor. As mentioned earlier, it is worth specifying the investor's initial interest in the letter of intent, which in major business culture most often takes the form of agreement as to the manner and purpose of negotiations, but it can perform many other functions. Its original name is letter of intent and refers to intentions of the parties, like behavior expressing and certain course of action. As this is, what has already been mentioned, an element of American legal culture, in the Polish legal language, this term covers all kinds of documents expressing the intention to conduct negotiations to conclude a contract. In practice, legal and economic trading in Poland usually does not distinguish between documents preceding the conclusion of the contract, such as the Memorandum of Understanding, the Memorandum of Intent, Letter of Understanding, which are collectively referred as to the letter of intent. From a legal perspective, the most important thing is the letter of intent does not contain, as a rule, in principle, declaration of intent aimed at creating a commitment, a legal bond. In principle, therefore, it is not a contract with legal effects. However, it is undeniable that such a document has some legal significance, if only because it means the start of negotiations, which should be conducted, as already indicated, in accordance with reliability, in order to conclude a contract. The content of the letter, as containing statements of knowledge, especially historical knowledge, can also be used in the event of discrepancies as to interpretation of the provisions of the investment agreement. In addition, the parties may expressly provide that certain provisions of the letter of intent are binding. An example is the conclusion of confidentiality provisions in the letter instead of entering into an NDA. Another example of binding clause may be a non-shop clause, in which we commit ourselves to negotiate with a given investor to refrain from negotiating with others who may potentially be interested. Most often, the content of the letter of intent will therefore oblige the parties to conduct negotiations in good faith, make arrangements regarding the distribution of cost by ongoing negotiations, as well as provisions regarding the confidentiality of information disclosed in the course of negotiations regarding their subject, course, trade secret of the parties. If we treat the letter of intent as a document initiating negotiations, it is also worth specifying the rules for communication between the parties. Very often, this avoids misunderstandings at the very beginning of shaping business relationships. A special aspect of the form of communication is the time to answer the question asked. This arrangement allows better planning of negotiations, as well as avoiding suspicions of ignoring messages. It should be remembered that a precise definition of the parties' obligations in negotiations may lead to the letter of intent being considered as a form of negotiation agreement, which is a contract of diligent performance. In legal transactions, this type of contract is rather encountered in the implementation of larger investment projects, and such a degree of formalization of relationship can be quite burdensome for a small entrepreneur. Without a doubt, however, it is worth specifying in the letter of intent when the negotiations will end. This can be done in a number of ways: by specifying the day, the duration of negotiations from the beginning, or by referring to a specific event, for example, a public tender. While the signing of such a letter gives grounds to determine when negotiations begin, it may not be easy to determine when they will end. A special type of letter of intent is a letter containing a summary of negotiated terms, most often referred to as a memorandum of understanding, or in the case of more complex contracts, especially term sheet investment contracts. Their basic feature is a fairly precise specification of the terms of the future contract, but due to their informal nature, they are as a rule devoid of standard legal formulas and written in an accessible language. The memorandum or term sheet, as indicated above, should cover the more important aspect of the contract without going into details. The purpose of preparing such documents is to ensure that the parties involved in a business transactions agree on most of its main aspects, which reduces the likelihood of unnecessary disputes in the future. They are also often made without participation of lawyers for two reasons. The first is to cut costs. The second, at this stage, most often the parties do not want to spoil the transaction by the participation of people who act in the legal interest of them, often wondering how he could agree on such unfavorable solutions at all. The nature of the legal profession contains the need to cool down the crazy impulses of clients, and from a business point of view, it's sometimes better to limit their participation. The presence of lawyers at the negotiation table before negotiating the wording of the investment agreement can be read as a tendency to significantly reduce risk appetite, which may not always be acceptable. However, this does not mean in discouraging you from using legal assistance. In the case of key issues, so-called deal breakers, consultation is highly recommended. They allow to avoid a situation in which, despite the well-negotiated terms, the investor and the investment agreement will not be closed because the negotiators overlooked important formal circumstances. An example resulting from other agreements concluded by the negotiating party. Quite often lawyers express their view on the importance of negotiating progress for assessing the behavior of the party, deciding to abandon the intention to conclude a contract. Following this path of reasoning, the more advanced the negotiations, the closer to conclusion of the contract, the more restrictive approach should be to the parties' right to break them unilaterally. It is also often indicated that the reason for the termination of negotiations should be given and the lack of adequate reason is considered to be contrary to appropriate legally accepted behavior. However, this view is not widely accepted, and there are also numerous voices about freedom to withdraw from negotiations. The second view cited undoubtedly strengthens the very weak structure of responsibility for the lack of negotiations diligence. Liability for damages due to negotiations carelessness under so-called culpa in contrahendo is limited to a negative contractual interest. It refers to actual losses, including as a result of the cost incurred to prepare for negotiations, and therefore the cost of expertise, research, and scientific works. Refers to actual losses, including as a result of the costs incurred to prepare for negotiations. And therefore, they might be, in example, cost of expertise, research, or scientific works. Negotiating parties, unless otherwise agreed, are not responsible for loss of business perspectives. So, in principle, withdrawing from negotiations does not pose any serious legal risk. This is one of the reasons why you should ensure proper documentation of your business talks. Letters of intent, memoranda, or written terms of future contract allow for assessing the business potential of the venture and the chances of its success. In this way, they enable the management of the founder's extremely valuable startup resource, which is his time. Thank you for your attention. In the next episode, we will deal with two specific types of pre-investment contracts: a business audit contract, so-called due diligence, and a preliminary investment contract. Bye-bye.